Don't worry about the membership list of Second Amendment organizations. The federal district court judge just issued a major ruling on this exact question of whether or not the Second Amendment organizations, such as the Second Amendment Foundation and the Firearms Policy Coalition, have to turn over their membership lists to Pam Bondi's Department of Justice. We'll break it down when we come right back. Major decision just now. Hey folks, I'm Mark Smith, host of the 4-Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment. Thank you, 2025 Gundies Awards. All right, we have a major decision just now, breaking news, in the Caleb Reese versus BATF case involving young adults. As you may recall, last week there was a big kerfluffle online and beyond about the fact that a judge, Judge Robert Summerhays, down there in Louisiana, entered an order, a final judgment, that directed the Second Amendment organizations of the Second Amendment Foundation and the Firearms Policy Coalition and others to turn over their membership lists, their private membership lists, to the federal government, to Pam Bondi and the Department of Justice. As soon as this came out, I told you it wasn't going to happen. Clearly a mistake. Not going anywhere. Nevertheless, a lot of people, online and otherwise, were very upset about this, attacking Pam Bondi's Attorney General's office and so on. But on Friday, the Department of Justice under Pam Bondi and Harmeet Dillon, in conjunction with the Second Amendment organizations, filed a joint motion to vacate the portion of the judgment dealing with turning over the membership list to the federal government, on the grounds that A, the federal government, meaning the Department of Justice, never, ever, ever asked for the list of members, and B, it would be inconsistent with the First Amendment, right to free speech and right to free association and so on. Well, I'm happy to report that just now, Judge Summerhays has just entered an order granting, essentially, the motion to amend or alter the judgment, and is hereby vacated, which means deleted, which means threw into the trash bin, the order that directed the Second Amendment organizations to turn over their membership list. In other words, a complete victory on the question of whether or not the Second Amendment organizations have to turn over their membership list to the federal government. The answer is they do not. Huge win for the Second Amendment, and entirely consistent with the request made by Pam Bondi's Department of Justice, where she specifically says, we don't want the lists. We did not ask for the lists. Asking for the list would be inconsistent with Department of Justice policy. And therefore, we don't think you should order the Second Amendment organizations to turn over the lists of members to us, the Department of Justice. And the judge agreed with Attorney General Pam Bondi and her lawyers in this case of Reese versus ATF. Here's what the judge had to say in vacating. Upon consideration of the joint motion to alter or amend the judgment, it is hereby ordered that the judgment of this court issued on October 7, 2025 is vacated. Is vacated. The court will set a telephone conference at its earliest opportunity to set a hearing on the motion to alter or amend judgment and set a briefing schedule if necessary. Judge Robert Summerhays, United States District Judge. Wow. Fantastic news. The federal district court judge has vacated his own order, which he did on his own initiative. Remember, as I explained before, the issue here was that Judge Robert Summerhays, obviously in a good faith attempt to kind of split the baby, entered this order directing the turning over a membership list to the federal government. He did not flag this issue ahead of time to the parties. He just did it on his own initiative. Now, what he should have done is what he's about to do now, which is he's going to come up with a proposed judgment. He's going to have a call with the parties. He's going to say, this is what I intend to enter, and he comments on it, and he discussions about it. That's the proper way of doing it. When you're a judge and you're going to do something that no one expects, or you haven't flagged with the parties, the right answer, of course, is you want to flag it with the parties and let them address it, good and bad and ugly. So in the end, I think there's only one conclusion we can draw from what just occurred here. And I think this graphic posted by a follower over on X really sums it all up as to where we are today. Yep, I think that basically summarizes this situation quite accurately. Let me know if you disagree, of course, in the comments below. With that said, the bottom line is right now, no membership list of any Second Amendment organization will be turned over to the Department of Justice. None of them will be turned over to Pam Bondi. None of them are going to be turned over to Harmeet Dillon. None of them are going to be turned over to the federal government or anything like that. Which is exactly what I said was going to happen, because it's simply not permitted under Supreme Court precedent. It's not permitted under the First Amendment. And as a practical matter, the United States Department of Justice just doesn't do these sorts of things for the various reasons we've discussed. Because you start interfering with the freedom of association. And this is long-standing precedent going all the way back to the civil rights era involving the NAACP, where, they were required to turn over membership lists, and they won court orders saying that that was not allowed. But we today, remember how I explained to you a brick back in the precedent back in the day, we can use today. So victories for the NAACP in the civil rights era, protecting membership lists of private organizations, is a precedent that we in the Second Amendment community can use today in the 21st century. So anyway, there you have it, folks. Hope this clarifies a few things. It's very good news. I'm not surprised. It's not surprising news in my view, but it's still very good news. It's always exciting to win, even if you expect it. And that is what just occurred today in the Reese case down there dealing with young adults in the federal district court there in the Western District of Louisiana. We'll keep you informed as this case continues to move forward. This is the kind of case that may eventually find its way up to the Supreme Court in terms of the scope of the remedy and the final judgment language. But again, the history of the future is yet to be written. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4boxofdiner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking to you again real soon here at the 4 Boxes Diner.